let's go ahead and get started. Well, good evening, everyone, and welcome to the Harris County Domestic Violence Coordinating Council's Deliberate Dialogues, the intersection of domestic violence and criminal justice. I'm Teachey Jenkins, the training director with the agency and Harris County Domestic Violence Coordinating Council. Our goal is to increase access and safety for survivors of domestic violence, hold batters accountable, and most importantly, to prevent domestic violence related homicides. And so we have started this series back in May. We've had an opportunity to look at the pre-conviction, post-conviction, and this evening we will be hearing information about our amazing court system and how they intersect with survivors of domestic violence. I would like, in honor of what occurred the other day in Uvalde, for us to do a moment of silence, because the work that all of you are diligently doing is a part of what happened. Recognizing that when trauma, perhaps in the lives and homes of our children, are left unattended to, how it can escalate. And even today, one of the teachers who passed away in that mass shooting, her spouse of 24 years passed away today of a heart attack, leaving behind 4 children. And so the violence continues. So let us have a moment of silence. All right, thank you. So at this time, I'm going to go ahead and turn it over to Barbie Bashir, Executive Director for Harris County Domestic Violence Coordinating Council, and she will be introducing our distinguished guest this evening. Barbie.
Thank you, Teachey. And thank you for acknowledging the tragedy in our state and in our world. Never to be underestimated how we're all impacted by such violence. Tonight is coming out of a lot of work for us as the coordinating council to really try to recognize how to ask for and implement change when we don't understand how our systems work in the first place. So we had a lot of conversations internally as a team and kind of wanted to think about the intersection of domestic violence cases with the criminal justice system, and what are the points that those cases, what are the touch points along the way? So we started, as Teachey said, in March with pre-conviction, and then we did post-conviction. We're not really going in any order because we're putting this on our website, and we will put it in an order on our website. But tonight we want to thank our guests for helping give us the foundation of what our court systems in Harris County look like, what they do, why they do what they do, how many there are, just like really giving us that foundational understanding of our court systems, so that we can be good stewards when we're working with clients, we can be good stewards when we're asking for change. So just coming to this from a really strong place of understanding. So with us tonight, we have 3 incredible human beings. Mr. Ed Wells, who's the court manager for the Harris County Office of Court Management. And he's going to speak with us first a little bit about magistrates and the misdemeanor courts. And then we have Eileen Gaffney and Lisa Teachey, who I think combined share a wealth of knowledge, wisdom, and experience of Harris County and our system. So Eileen and Lisa, thank you for bringing all of those years of experience and dedication and hard work to this evening. And Ed, thank you as well for being here. We're going to turn it over to Ed. I think you're going to show a PowerPoint. Rebecca should have set it up for you to have the ability to share your screen, so you can just press the share your screen button, and we'll sit back and listen.
Thank you. Very good. Okay, can y'all see slide with the courthouses in the background?
We do.
Perfect. All right, so I'm going to go through some of this very quickly, but I wanted to put it into a PowerPoint so that y'all would have some reference material after the fact to look at. This office represents the county criminal courts at law, and we also represent the probable cause court. And so quite a bit of coverage we have to provide in cases that involve domestic violence in the criminal world. So let's jump right into that. It is not letting me advance slides. That's not good. So you know what? We're going to do this a little different. Let me stop the share real quick. We'll go to this view of it.
The screen, they look like they were advancing.
Oh, were they? They weren't on my end.
Yeah, they were advancing on this end.
Okay, well then let's go back. I can follow that easy enough because it'll be a bigger view for you. Don't we love technology? All right, let's go back. Okay, now they're working for me. So the county criminal courts at law, we'll start there with just a brief description of what these courts are. They're statutory courts created with criminal jurisdiction for all misdemeanors where the fine exceeds $500 and confinement is a sentencing option not to exceed 1 year in the county jail. They have concurrent jurisdiction with the Harris County Civil Courts at law to hear appeals of the suspension of a driver's license, jurisdiction to grant occupational driver's licenses, and appellate jurisdiction in appeals of criminal cases from justice courts and municipal courts in the county. That's a piece of work that people don't pay attention to, but there's a fair bit of appellate work that comes through our courts. Just a brief view of the state judiciary. This yellow highlighted area here is where the county courts, statutory county courts in particular, are found. This is blown up to show that jurisdiction. We fall into this group here in the middle. And so this provides statewide for jurisdiction of all county courts at law. In Harris County, we have specialized courts. So the 16 courts only hear criminal misdemeanor cases. Our office again supports the 16 county criminal courts at law, the 4 county civil courts at law, 16 justice courts spread across the county, the 24-hour probable cause court, and then this office. These bullets here are a good description of the kinds of things that we do. We're here to make justice better in the courts that we support, and we do it through these kinds of things. I think that Harris County is blessed to have the resources we have for offices like ours, administrative offices, because it does make what happens in the courtroom better. It makes it easier for judges to do better work. And at the end of the day, that contributes to better justice. Our mission in this office and our courts is to assist the Harris County and Justice Courts in their ability to provide a forum for the fair, impartial, accessible, and timely resolution of cases. We push that very hard because timeliness is a part of justice, especially when there are victims involved. We accomplish this through collaboration, technologies, justice community leadership. That's a very important role for judges and courts in general. Continual monitoring, evaluation, and improvement of court and justice practices. We have a vision statement that is consistent with the purposes and responsibilities of courts, and everything we do is based in that. If you had some of my staff or even judges answering questions here, they would tell you they hear that all the time because they do. Everything we do is with the concept of better justice based on the purposes and responsibilities of courts. We take it very seriously. And we want to spread that mindset and let others know this is what we're doing and why. This is a quick view of our overall caseload. Active cases pending from 2012 through April of 22. You'll see the big increase, in these different colors represent different case categories that we've created to track our caseload. You'll see DWI and family assault make up a significant part of our caseload. Those two offense categories really are some of the more serious cases that we deal with in the county criminal courts at law. And you'll notice how the active cases pending has grown tremendously. If you follow along the timeline at the bottom, what you'll notice is mid-late 2017, we start to see that rapid increase. For those of us who don't remember or don't want to, that's when Hurricane Harvey occurred. We lost the use of the Criminal Justice Center for a very, very long, more than, well, I didn't return here for almost 3 years. And so our courts were impacted. We didn't have facilities. We had courts sharing courtrooms. We didn't have good access to jury service. We had no jury service for a period of time, which meant we couldn't hold trials. And when that occurs, this is what you see is a backlog of cases, a backup of cases. Compounding that in 2020 was the COVID pandemic, where we had just gotten back into the courthouse. We were starting to hold trials again. And suddenly we have all the issues of social distancing, courtroom capacities. You know, we had for an extended period of time, our courthouse was closed on Fridays every week. So we only had 4 days out of the week instead of 5. All of these things contributed to the backlog. And one other piece, which doesn't get talked about as much, and that's the volume and complexity of evidence in our cases. DWI in particular, but really all case types have been impacted by this, most significantly body cam video. The volume of body cam video has risen dramatically. The backlog in making that video available to the prosecutors and defense for our courts has really gone at times a year to get video, if not a little longer. And that really does slow down the processing of cases. This is a slightly different look at our caseload based on age of caseload. We look at age of caseload because we have buckets, so to speak, of cases based on how old they are from the time of filing or arrest to, well, at whatever point in the life of the case they're at that time. And so what you see again is a relatively stable caseload. Looking at this, the red represents cases over a year old. The more pink or peach represents those 6 months to a year. And in a normal operating court under normal circumstances with all of the things that we had pre-Harvey, pre-pandemic, you would see a very small percentage of cases in those two older buckets and the majority of cases in the other three. Obviously, with the impact of Harvey and the pandemic, that has changed dramatically. The good news is if you look at the very top and far right side of that, you start to see it tailing off as we have emerged somewhat from the pandemic, as we have more access to jury panels and an ability to hold more trials and really expose more cases to trial. We're starting to see dispositions rise and our active cases pending has gone down. And that's really good news and a trend that we've been working to accomplish for a long time. These are just some definitions for y'all to refer back to, some of the statistics we talk about: age of caseload, active cases pending, and clearance rate. What do those things mean? And then at the bottom are the model time standards for criminal cases. You can see all the groups that contributed to creating those time standards. Last view of our misdemeanor caseload. June 2011 to 2017, you see relative stability again. In 2017, you see that dramatic increase, especially in the cases 6 months to a year and a year or more. Other thing that is represented here is June of 2011, we had 13,437 cases pending. Today, it's 36,371. The high was actually almost 41,000. And so we've cut into that backlog almost 5,000 cases and continue to do that. Judges are working as effectively and efficiently as they can. We're holding trials more often. All of these things we're starting to see the benefit of it, and more cases are being disposed of. I went through that pretty quick, and so we'll have some time for questions at the end. On to our probable cause court. Harris County has a 24/7 probable cause court or magistrates court that operates inside the Joint Processing Center, where people who are arrested on a Class B or above offense are taken to be booked into the county jail. When they arrive, they go through the booking process. As they're going, or actually prior to the booking process, their case has already been reviewed by the district attorney's office and filed by the district clerk. So they have a case, they know what court they're going to. All of this happens very, very quickly. And that volume is averaging about 300 intakes a day. So 300 people hitting the JPC and being booked into the jail a day. At probable cause, the first thing they do when a defendant is presented to a magistrate is they determine, is there probable cause? And probable cause means, are the elements of the offense present to a degree or enough evidence of it for further detention? That does not mean that someone will be detained. It only means that they can keep them there for that time. There's enough evidence to proceed, and they proceed immediately to magistration, where the criminal law hearing officers or magistrates give warnings to defendants. They set bonds. They consider the possibility of a personal bond in those cases. They also consider conditions of release to address any mitigate or aggravating factors, such as someone has been arrested before and was a flight risk. How do we mitigate that? Or someone is a risk to public safety or that of a victim. How can we do things to protect the public or protect the victim? In addition to those basic things that happen on dockets throughout the day and night, the hearing officers also do other things. They review probable cause for the issuance of emergency protective orders. They review arrest and approve arrest warrants, search warrants, and mental health warrants. They administer magistrates warnings on out-of-county and out-of-state fugitive cases. Someone with a warrant out of county or out of state is arrested, and the magistrate here reviews that to determine, was it a lawful arrest, and then they are processed appropriately. And finally, in the last 2.5 years, I guess it's been, they review notifications in accordance with CCP Article 1622, which is a mental health screen. When the sheriff or arresting the law enforcement agency that is holding the defendant gives information to the magistrate that someone may have a mental health issue, they may be in mental health crisis, they have a mental health history. The magistrate reviews that information and then can order that a screen be done. The results of that screen by a medical or mental health official are relayed to the trial court for the next setting that defendant appears in. That Article 1622 is more commonly referred to as the Sandra Bland Act. And so that's to prevent things like that to the extent we can from occurring in our jails. Give you an idea of how much work goes through our probable cause court. This for 2021, 66,518 Class B, A, and felony cases were on the PC court docket. On the PC court docket is significant because there were a lot more people that were brought to the JPC. But these people did not bond out before their appearance before a magistrate. That total number would be closer to 100,000 with regard to how many are presented at the JPC annually. 34,250 Class C fine-only cases on the PC court docket. So someone is arrested on a higher charge and they had outstanding Class C cases. One of the unique things about the criminal law hearing officers in Harris County is they have jurisdiction to dispose of that Class C. Most of the time, a defendant's time in the JPC will be sufficient to take care of the Class C just based on time served. Some people avail themselves of that, some do not. 6,803 mental health warrants, 31,542 1622 orders issued in 2021. And then when we talked earlier about what magistrates do, there were those other duties. That other work from January to April of 2022 is averaging 3,600 and change documents that the hearing officers are reviewing every single month. So there's a lot of work there. They again work inside a jail facility. It's 24/7 operation. That court does not shut down. It operated through Harvey, except for a couple of moves when we had facility issues that required it. We had judges and staff that were caught at work for about 36 hours because they couldn't get out and new staff couldn't get in. And that's just what they do. And so it's a big, very important job because they are protecting the rights of individuals back to the finding of probable cause. If they find no probable cause or no PC, that defendant is released immediately. And in many of those cases where no PC is found, they are dismissed by the district attorney later, but not all. I know I'm going pretty fast, but there's a fair bit of stuff here. So on to the family violence or domestic violence cases in the county criminal courts. We have two categories, assaultive and protective order violations. These are the penal code sections that apply in the misdemeanor courts. When you saw that chart earlier, you saw kind of the volume of that and the backlog of cases. Filings have increased as well. This is the backlog of just assault family in the misdemeanor courts. Again, that increase in the active cases pending resulting from Harvey largely and the pandemic. It's a similar curve to our entire caseload. This is the blue represents the assault family member cases. The scale for those cases is on the left, and our total caseload, the orange, is the scale is on the right. But as you see, it follows the slope. Nothing differently is happening with those cases. We're getting to them as quickly as we possibly can. I will note, and I should have pointed this out earlier, you see the flag on there for the COVID-19 disaster declaration. When that was put into place, our 16 county criminal courts, who each had their own courtroom and could operate all day in their courtroom, were reduced down to 4 courtrooms for a little over a month. And so we had 4 courts at that point in time sharing a single courtroom 4 days a week. So basically, a court wasn't even getting the equivalent of 1 day a week. And so it had a tremendous impact on our backlog. Fortunately, as things eased up, we went from 4 courtrooms to 8, eventually back to 16, and then eventually back to something closer to normal operations. This is a chart, again, 2015 to 2022, and assault family member cases represented in blue, and terroristic threat of family member or someone residing in the same household represented in red. That data doesn't go back as far. I think there was a statutory change that made that a Class B, and so that's why those started appearing. But again, you can see the uptick. These are cases filed, so filings have increased corresponding with Harvey and the pandemic. And I think all of us recognize the stress the communities have been under, and that's contributed to more of these cases being filed. That's one of the other reasons that that piece of our caseload has grown, because filings have gone up. Protective order violations. So someone is arrested on an assault family member. As part of the conditions of release, a protective order is put in place. Sometimes that can include no contact. Sometimes it's no harassing or threatening communications, things of that nature. But when someone violates that protective order, that's an offense all to itself. And it's actually, under some circumstances, depending on the circumstance, is the rare circumstance where a misdemeanor court can find someone and hold them at no bond. That's a provision that is a rarity in the county courts, but it is a possibility at times. But we take these cases very seriously. We recognize trying to protect a victim, and I know I'm preaching to the choir here, but this is a very, very important thing. When a protective order is put in place, it's because people recognize there's some risk, but there is other harm that would be created by holding someone in custody. At the same time, when someone violates that protective order, the court has no choice but to take it very seriously. And from that point forward, they're taking a much closer look at things. Usually, it goes from what might have been a personal bond to a money required bond. Sometimes additional conditions are required, or again, ultimately someone can be held at no bond. Again, cases filed here, violation of protective orders, you see that increase again. Again, with Harvey, a small increase really in 2019, but then an uptick in 2020 through the pandemic, when I think even more stressors were placed on the community as a whole. Last, this is just a look at our caseload, the dispositions in assault family violence. We have these categorized by different dispositions. The biggest groups, of course, no surprise, someone can be acquitted. There's a deferred adjudication, there's a conviction, or there's a dismissal. And one of the things about the dismissals are that some number of those are not a case truly dismissed just because the case wasn't good. We have a pretrial intervention. We don't, the DA's office does, for family violence. And so if someone enters into that pretrial intervention program and successfully completes it, then that case ends in a dismissal, preventing them from having a record and moving forward. That said, there still is a record held by the district attorney's office should there be a new offense in the future. And that's the end of my section. So I'm going to unshare, and then I'll be happy to answer any questions at the end. And unless somebody has a question now, I'll turn it over to Lisa and Eileen.
Can I ask a quick question, Ed, on the last slide that you just showed?
Mm-hmm.
For the convictions, it looked like conviction numbers went down considerably in 2019. And are you attributing that as well to Harvey?
It is. It's a part of the backlog. You'll also see, though, from, I'll pull it back up real quick. It's not letting me. Well, anyway, y'all will have a copy of this. But very quickly, the dismissals increased during that same time frame. That was the start of the pretrial intervention program. And so convictions went down because cases were disposed without a conviction, but the person went through the pretrial intervention program, which includes, anger management, BIP classes, things of that nature. They did it successfully, and so their case was dismissed.
Got it.
That's a district attorney program where the court agrees to reset the case into the future on a date where the person is supposed to have completed everything. If they do that successfully, the district attorney offers a dismissal and the court can approve that.
Okay, thank you.
You're welcome.
And just one other quick question before we take it to the next felony courts. So magistrates, do magistrates have a, we talk a lot about standard operating procedures for law enforcement. Do magistrates also have the same kind of rules that structure how they are to hear and adhere to court proceedings?
They do. And so in CCP 1517 are the requirements for magistration. Articles 17, 15 are what they consider for bail. And those are the rules of the road for them. Within that, they have some discretion with regard to consideration of a personal bond, setting a bail amount, and again, the conditions, other conditions of release they can provide. But that's what guides them in making those decisions. Senate Bill 6 that was passed and became effective April 1st also changed that a little bit and took some discretion away in a small group of cases.
Fantastic. And how are magistrates hired?
So they are appointed by a committee of judges that is made up. It's a statutory committee. There are 3 felony district court judges, 3 county criminal court judges, and 3 justice court judges who represent all of the judges hearing criminal cases. And that committee reviews, when we have openings, they'll post the opening, they receive applications, they review them, interview people, and make appointments from there.
Got it.
We also have a chief hearing officer that manages their day-to-day operations.
Okay. And is there a time frame for an appointment, or is it just until the person doesn't want to do that anymore?
No, by statute, it's a 1-year appointment.
Okay.
If at the end of a year they are not reappointed, they remain in their position until either they are reappointed or a new person is appointed into that position. But typically their appointment is a year, and we reappoint as appropriate every year.
Okay. And another question, can the public weigh in about appointments? Do we have any ability to voice concerns or even kudos for appointments?
Sure. So the magistrates fall under the same judicial canons that elected judges do. So if there's a specific complaint, that complaint can go to the Commission on Judicial Conduct. If it's something that maybe you don't feel warrants that, you can certainly make me aware of it. And
Okay.
I'm happy to take that into consideration depending on what the concern is. I'll share it with the chief hearing officer, or I'll share it with the committee. That has happened in the past. One of the other things that's unique about the work of the magistrates there, everything they do in a docket is on camera. And so we can review that after the fact. If there's a complaint about a specific case, we can pull the video for that case and review exactly what happened. And, more times than not, the context of what occurred is different when you view the video and you see the behavior of everyone involved. The defendant, the assistant public defender representing them, the remarks from the DA, other things going on. And but we do look at that on a regular basis and actually use that as a part of our evaluations of hearing officers.
Yeah. Alicia, you're in my head. That was my next question as well. Does the public have access to those videos? I know from time to time we'll see snippets on the news where they'll show clips from some of those hearings, but are those things that, like, if I wanted to just tune in and watch some of those hearings, can I do that? Or can I go back and find archived footage to do that?
Yeah, you can't tune in and watch it live, although there is an observation area in the Joint Processing Center where you can see what's happening live in the courtroom via a monitor.
Okay.
But archived videos, yes, if you make a public information request or a Rule 12 request since it's courts, then yes, you can. And we get that request on a fairly regular basis from media, in other jurisdictions sometime when someone is arrested on an out of county or out of state. And we just need a defendant name and case number or a date or a specific docket, the 2 a.m. docket on Saturday, whatever. And we can pull that and provide it.
Excellent. All right, I think for now we'll let you take a breather, and thank you so
I'm having a shot of
much.
coffee.
Your
So
slides are fantastic.
his slides are, we didn't do slides, guys. I am so sorry that we did not, but we do at least have some statistics information we can share. I'm going to do a much more, a broader overview. Lisa can do the deep dive for y'all into felony, right? So your next level up in courts is really your district courts, right? They're courts of general jurisdiction. In most places in Texas, a district court hears everything. They hear criminal cases, they hear civil cases, they hear family cases, they hear election disputes, right? I mean, you go up to Corsicana, you're getting Judge Longwadino, I think is his name. He does everything. He's it. He's the only district judge there, right? We're lucky enough in Harris County or not, whichever way you look at it, that we get to specialize, right? So you have judges who, although they're a court of general jurisdiction, they primarily do felony work or family law work or civil work, right? And then you have the 280th Protective Order Court, which I'm sure y'all are familiar with as well. And one of the more unique things I think about domestic violence is it can cross numerous divisions, right? The victims, the applicants, the people that you're going to try to help can find themselves not only as the complainant in a criminal case, they can find themselves as the applicant in a family law protective order application. They can find themselves either as the petitioner or a respondent in a family law case, because a lot of times what happens with those domestic violence cases is if it's a partner domestic violence and if they have kids, they then find themselves in a whole another kettle of fish. And also, depending where it is, you could find yourself with damages that you're having to bring in, that you could find your client in a civil court suddenly. And one of the very interesting things is one court's not supposed to hold up for another court, right? And in fact, if you go to the family violence bench book, which is online, I mean, if you all said, you know what, I want to see what that says. I'd like to understand how they're telling our judges how they should look at family violence. You can Google Texas Family Law Bench Book. There it is for anybody to kind of take a look at and get a feeling of what the requirements are from the judge's standpoint and what they have to look at. And one of those requirements is that a criminal judge doesn't get to go, yeah, well, you got that civil protective order, so I'm not going to worry about your felony case that's kind of in front of me, right? Because you'll go take care of that in the civil court. And the civil judge doesn't get to go, well, you got that magistrate's order of protection, so why in the world am I going to care about your client thinks they want a protective order that's going to be 1 year, 2 years, or more in length. So each court is to take the issue and kind of immediately on its own side. I found it very fascinating. I looked at the Texas Criminal Justice Victim Services Division. So I'm sure you all know that they're out there. If you don't, I'll share their information. And so you can register with them, right? And when you register with them, they can provide certain types of assistance. What I found fascinating is that in 2021, only 20% of the registrants were not related to some type of assaultive crime. So you think about that, right? 80% were survivors of a homicide, stalking, domestic violence, family violence, child abuse, adult sexual abuse, adult physical abuse. So that's 80% of the individuals who are registering for assistance from the Victims Assistance Division. It's pretty amazing. And when you think about it, right, those are all assaultive, violent kind of crimes. We didn't take domestic violence, right? We give that a very specific definition as to how we look at that. But that's 21. If you take just domestic violence, you take out child abuse, you take out just domestic violence, 21% of the individuals who register for assistance are domestic violence individuals. That is the same amount as victims from a homicide. So people who want to make sure they keep their addresses confidential, people who want to make sure they get notification if somebody is getting out of the criminal system, right? Individuals who need other help and other assistance. And I thought that that was a pretty staggering number, to be honest with you. Just shows me kind of how high that need is. And because there's so much crossover between our divisions, between civil, family, protective order court, and criminal court, I would tell you one of the most important things you can do is make sure you get your clients, if they're entitled, right, get that victim the best protective order they can get. Because we are so backlogged. Lisa will give you the numbers. We are so backlogged in our felony system. Even if you make it a condition of bond, which they can do, even if that gets reported up, there's just something different about that protective order and the ability to have a second criminal case brought for the violation of that protective order that has a lot more power and a lot more strength when it goes into the system. Because even though our legislature passed a bill saying basically we now have to somehow magically register conditions as if they were protective orders, I still don't think that that's worked out in a way that's going to have the same force and effect as an actual protective order for individuals to kind of get the help that they need. I'm going to let Lisa do a deep dive into some of our numbers of what our courts are doing and the dashboards that are available. And then kind of, there may be some questions and we can kind of get into where the difference is, like what makes a misdemeanor, right? And what makes it a felony when you get into domestic violence? Like, how do you know kind of where you're going to land?
Yeah. And Lisa, also can you add just a description of the felony courts and the numbers and, just so pretend like we know nothing about what a felony court is.
Okay, so the felony courts in Harris County there are 23 of them now. There used to be 22. For almost 30 years, there were only 22, and there have been studies that show that Harris County probably needs 17 additional felony district courts. But we got one new one last year, and so now we're up to 23. A felony district court will handle anything in the penal code, a crime, what we would call a crime, that would result in prison time. Misdemeanor courts are jail time or fines. Felony courts are prison time all the way up to the death penalty. So where you don't go to jail when you come here, you actually go to prison, well, except for a state jail felony. You go to a state jail for that. But so that's kind of how you think of the difference. The misdemeanor, you spend your time in Harris County, in the Harris County jail, or if you're on probation, I guess you're still just on probation in Harris County. But in a felony, you're going to go to prison and all the way up to the death penalty. So, in Harris County, we have 61 district courts. I know that there are 23 family. I know that there are 3 juvenile, but I can't do the math to divide up family and civil because that's Eileen's area, and I don't have the bandwidth to hold that in my head. So, but so some of our cases cross over into the family district courts, and I'll let Eileen explain what that jurisdiction is and that's about. And some of them come into the felony courts, and that would be the higher level penal code offenses that result in prison time. And some of them are in juvenile, and some of them, I guess, could be in civil for some sort of lawsuit, property dispute or something like that. So amongst our 23 courts right now, I don't have a lovely PowerPoint to show you, but I can tell you how to get to our dashboards all the time. The felony court website, which I'm trying to get changed, is www.justex.net. I don't know what that means, but it's JUSTEX.net. I'm trying to get us to get like Harris County District Courts.gov that will link to this. But so you go to justex.net, and on the left side there's a little navigation menu, and you can click on courts. And if you click on courts, because Barbie, I think you're doing this along with me, at least it looks like it. You go to courts on the left, and then you click on criminal. That will be your felony courts. It doesn't say felony, but Justex is only the district courts. And the misdemeanor courts have a different website. And so you click on criminal, and then you go down to the bottom, and you can see it's the second from the bottom, district courts dashboards. Those are updated kind of a month behind because we're in May now, but so these have April statistics. On the left, you'll see active pending cases. I don't know, as people who are constantly in the criminal justice system, this may not come as a shock to you, but it comes to it. It is a shock to me every single time I look at this dashboard that we have 47,577 pending cases. That is a lot of cases to be pending. And so on the left, you can see the breakdown per court, the average number of cases in a pending in any felony district court at any time is 2,163. But that's all felonies. That's just not those that involve family violence. That's every kind of felony that can be charged, that someone could face charges on. And if you go over on the right, there's the age of the caseload, how long. You can see that actually this one is the criminal district courts at the start of business on Sunday, May 1st. So that one's for May, but we have, and that shows that most of our 17,000 plus of our cases, 37% are older than 361 days. That's the backlog. That's what we're talking about with Harvey, with the snowpocalypse, with the pandemic. What I think a lot of the public doesn't realize is that misdemeanor courts and felony courts had touched on this. We were pretty much locked out of our courthouse for 4+ years because of the devastation of Harvey and the amount of construction that needed to be redone on it. We just moved back in December 2020 or December 2019, I think it is 2019, because it was right before the pandemic, right? Or right after the pandemic. Do I have my dates wrong? So for 4 years, we're doubled up or having jail dockets and misdemeanors having the same issues we are there. I think they had to crowd back into the family law center at the time.
They did.
And I mean, where we were bringing defendants over in buses, those were the holdover cells. So this starts in August of 2017. We can't catch a break. Then snowpocalypse happens. Then the pandemic happens and just virtually completely shuts us down. Not only are we crowded and doubled up and holding jail dockets, and every other week are we able to hold a jail docket or a bond docket. Now the pandemic just shuts us down completely and everybody's got to go home, and we got to figure out how we do all of this over Zoom. And when you think about, well, why didn't y'all just turn on Zoom? Well, there are constitutional protections for people facing charges in misdemeanor court and in felony court. The right to confrontation, the right to be in the same room as your accuser, the right to cross-examine your accuser. And so the Texas Supreme Court and the Court of Criminal Appeals had to figure all that out. And how would we do that? And so basically we could just sort of do bond dockets. We couldn't really do trials and move all of those cases because there are sometimes when you can have a virtual hearing on the felony side, but you have to be mindful of the right to cross-examine and the right to be in the same room. It's not like civil. Civil could almost go straight into a Zoom hearing. Almost, I'm not quite. She's gonna jump up in a minute and tell me stop making it sound like something that's not over there. So that's a whole other thing. And then recently, what we have recently, where the grid went down. That was snowpocalypse. So those are some of the kinds of things that we're facing. And we even with our 24-hour operations of the magistrate court, where we're cycling people through, they've still got to get to the home courts.
But which is one reason I say, right, knowing where Harris County is, it's so important to not leave out the other sources of where you can get help and assistance for somebody. Because if we're backed up in the felony courts that much that somebody hasn't gone to trial,
You wake him up.
right, and they can't, right? So you've got to find other ways to provide some relief and assistance to those victims, right? Whether that's going to be, okay, I can't get it because I'm not going to get this conviction over here because it's going to take a while, right? Do I want to go see if I can get a civil protective order, or do I even want to get a restraining order from one of my family courts that at least is going to provide some layer of protection, right? And kind of let things move forward. All right, sorry, Lisa.
No, thank you very much. So that's
Lisa,
kind of how.
Can I ask a question about, so these 23 courts, so let's imagine there's no backlog. And cases are flowing in. How does it get decided how a case gets assigned to a court?
We have a direct filing order in Harris County. And in the old days, when I first started here, what was that, Amy, 20 years ago around, what the police officer would walk over to where the juvenile court is now, because that used to be the criminal courthouse. They'd walk over to the district clerk to file the charges. The district clerk would spin this basket that had 22 balls in it, and they'd pick the ball out and assign it to that court. And that's how every case has to come in. There are some rules of attraction, like if there's already a case pending with the person or this incident, that it would attract to the same court. All we've done is computerize that ball spinning. There are some other rules about capital cases and how they work. And if there's an administrative judge, what happens, and her caseload, right now it's Kelly Johnson, that's why I say her. But it's supposed to be a random assignment, just a computerization of it with some attraction laws. You can go back to justtext.net where you found the dashboards, and you can go to courts again and go to criminal. And right above where it says district courts dashboard is the archaic direct filing order. And that will explain how every case gets assigned to every court. This is our order to the Harris County District Court of how to assign our cases. And Ed, I think y'all have a direct filing order as well. It's the same system, basically. Different order.
It
And,
works
and
exactly
did that
the same.
change at all with the pandemic? Did everything just remained the same? And then we had these community crises, right?
Exactly.
Okay.
Ed, and y'all are the same way, right?
We are. Yeah, we have a direct filing order that and it's very similar rules of attraction. So if someone has an open pending case or they're on probation, had a DWI within a period of time, they go back to the same court that their original case was in.
And Lisa, Ed described that the addition of body cam footage and requests for that to enter into the records has created another dynamic for backlogs. Is that the same for felony courts?
Absolutely. It is the bane of our existence right now, trying to, first of all, get the backlog cameras, trying to have consistent cameras amongst the agencies. That would go a long way in helping us. And then having an easy way to get it to the defense. Right now, the DA tries to get it and put it through the portal. And yes, the body cam footage is an extraordinary obstacle that we are facing right now, and ways to overcome or get that more efficient, not overcome, but to get that, the production of that evidence more efficient.
So you just mentioned consistency of cameras across agencies. Can you talk about that a little bit?
Ed, were you going to jump in on that? Because I'll let you.
I'm happy to. Yeah.
Thank you.
There are 80 plus law enforcement agencies in Harris County that file cases in our courts. And they're all funded independently through the municipality, the school districts, all these different things. And so when they buy body cam systems for their law enforcement agency, they buy what they think is best for them, or they buy what's best at that time. And so over the course of time, we end up with video coming in 15, 20 different formats, sometimes proprietary formats where you have to have specific software or equipment to be able to view it. That makes it very, very difficult for the courts to use it, certainly for the prosecutor and defense to view things. Another thing about the body cam, and I just want to touch on this quickly, when we talk about the volume, keep in mind, we've had video evidence for some time, but let's look at a DWI case quickly. 10 years ago, there was no body cam. There was probably a dash cam. Largely, there was no blood evidence, so a blood draw wasn't taken then. Today, all of those things happen, and we have body cam on one or two officers from the patrol vehicle. If another vehicle comes to the scene, that's one or two more officers. We have a video of the blood draw. We have video of a field sobriety test. We generally have video of a sobriety test at the local police station or arresting station. All of that video has to be viewed by someone. The state is looking for anything incriminating. The defense is looking for that 20-second video or 10-second piece of hours and hours of video that tilt things in favor of their client. And so if it takes us an inordinate amount of time just to get it for the attorneys, then they still have to view it, right? And none of that existed 10 years ago. And so this has become a significant issue for the processing of courts. The statistic Lisa referred to earlier about the need for additional felony courts, that's true of both court divisions, but it's the complexity of things, not just the sheer volume of cases filed, that have changed the nature of our work.
Absolutely.
So Ed, I'm sorry, I'm jumping in here, but Ed, I wanted to touch on something that you said, and this goes to, all three of y'all actually. You said something about the blood draw. And so is not only do you have to wait for the body cam video, but you also have to wait for the scientific evidence. Is there a backlog in getting like the blood draws, like if there's a sexual assault kit, forensic exams, forensic interviews with kids and adults and all that stuff? Is that also causing some of the issues?
Blood draws are not generally today. Like body cam delays today, blood draws were an issue several years ago. There was a huge backlog in the labs waiting on analysis to come back. That's largely been, you shine a light bright enough on something, people start to pay attention, and additional resources came to the labs so that they could catch up. And so today, I'd say it's rare that we have to wait more than a month for blood analysis. Other types of analysis, though, can take longer. And I think that probably affects the felony courts more than it does ours. We have some of those things in our courts, but not the volume you would see in a felony court.
And just a reminder that television shows like CSI and Law and Order have done us no favors. You don't get it that fast. There's no glass panel sitting somewhere where we switch our fingers across and zoom in on the DNA molecules and all of that. It's not like that. It takes a long time, and it's a bunch of graphs and numbers that somebody has to interpret still.
And Amy, I think, from the standpoint for forensic interviews with kids, right? That also depends on where it got done. We have some places that do that turnaround pretty quickly and make those videos available pretty uniformly. And we have some other divisions that, other jurisdictions that may not be quite as good at making sure that happens in a timely way.
And for all of that evidence that has to be scientific evidence, we get the attorneys the state gets the results back. But for those cases that go to trial, now you're introducing additional experts. So what used to be in a DWI case, a day and a half trial, can easily go 2-3 days now, because you have so much more to cover in that trial. And I know that's true for the felony courts as well.
Absolutely, absolutely.
And then we have the jockeying of horses, right? So you only have so many people who have been willing to come down to be jurors during the pandemic. I mean, I don't know if y'all realize Harris County tried more jury trials than I think any jurisdiction in the country during the pandemic and the depth of the pandemic. But even that, is that right, Ed?
No, and absolutely that's right. And tried more cases than the rest of the state put together.
It's still a thimble of kind of what's needed. And so, you get into some also who gets to go to trial, and there's certain statutes that talk to who gets priority. As you wouldn't be surprised, that kind of starts off with individuals who are actually incarcerated. So defendants who are sitting in jail awaiting their day in court get to go before others. You then deal with some assaultive cases that relate to children under 14. Really high up on the list are your domestic violence cases, believe it or not, by statute. But still, you have every court wanting the same resource, right? And they've got to make a decision. Maybe that capital murder case, even though it may in theory be lower, needs to go for some other reasons, witness reasons, everything that kind of goes into it. And so we have lots of factors that go into kind of the slowdown in getting to trial.
And I really want to thank you all for addressing the backlog, because I think that what we're trying to get at is twofold here. One is a basic understanding of our court systems and how they work. Because until we know that, then we can't understand the true complexity of the backlog, right? So having both talked about at the same time is really important. I want to make sure that we have time for audience members to ask questions. So I'm going to ask folks, you can drop your question in the chat, or if you want to unmute yourself and come on camera, or stay off camera and unmute yourself, there's a raise your hand function, or you can just wave your hand. I can see you. And I'd like, to open it up for some questions. I also have a couple of other questions that I want to ask, and I'll reserve that to closer to the end. So Alicia.
Thank you so much. And thank you for sharing this information. It's just fascinating to, and I can only imagine all the logistics that went into it with all the different issues that Harris County has faced in the past couple of years. So I just am in awe of how, our court system, how you all were trying to manage all of that. So thank you so much. I actually have two questions. Having this bird's eye view, it was fantastic to see the graphs of the different types of cases that come through. Having this bird's eye view of it, so to speak, and seeing the caseloads, especially with domestic violence, or just even with DWI, because I saw that was also high. There were lots of cases that were coming through that were DWI. Do you then take that information and apply it some way just for the judges? For instance, during COVID, during some of these tragic, these issues that we were having, there were new programs that were set up, new community programs, new technology that was being looked at. And how do judges keep up to date with all of that information? So, are there ongoing, and who might be responsible for making sure that education is offered to the judges? I know there's state statute of, hey, our judges need to be trained on all sorts of stuff, but, just making sure that judges are understanding of different resources that are available, different technology that's available, who can do that? And then the next thing is, how do you, see the cases? So for instance, that uptick in DWI, do you all take kind of a stance that, hey, we're seeing this here in Harris County, so let's boost your education about those resources and information regarding this? So DWI or domestic violence, like there's so much that's come out the past few years about traumatic brain injury and, all sorts of things that funnel into domestic violence. I just think it would be helpful for everybody to have that knowledge.
Ed, do you want to go first? Or you want me to go
Sure.
first?
I will. Yeah. So you're correct. We do offer training for judges locally. We'll bring in outside speakers sometimes. Sometimes we do that ourselves. We do look absolutely at all of that statistical information, trying to figure out where are our pain points, so to speak. Where are the real clogs in the system? Where are the most dangerous things that we need to address? Another source of education for judges, there are requirements for judicial education. The Texas Center for the Judiciary provides education. I know judges in the past have had specific education here locally on different impacts of substance abuse on the brain, how that impacts development of the brain in an adolescent or a young adult, things of that nature. DWIs, we've had education multiple times. We have DWI courts specifically to look at the highest risk DWI offenders. So we are always reviewing that in the hopes, again, of preparing our judges to be better equipped to look at individualized justice in individual cases. Lisa?
Yeah, and it's the same thing on the felony side. We do an in-house training every year. It's kind of been difficult during COVID to do some of that, but we try to provide at least 15 hours of training, and we often try to provide 3 hours of family violence because judges have a requirement, all judges have a requirement to get training in family violence. That's a mandate from the Texas Center for the Judiciary of the hours that they have to have. We've had Barbie come before, we've had Amy come before, we've had the Teachey Center has come. We've had other family violence experts come and talk. And so we try to provide that for our judges in addition to everything. We also have therapeutic courts. The the process of people cycling through our courts has become a real issue of repeat people who are cycling through, and the judiciary is taking notice of that. And we are starting to develop more therapeutic courts than just a drug court. I mean, almost everybody has heard of a drug court. Those have been around 10, 15 years now. I don't know if it's that long, but I think it's that long. But we're moving toward more therapeutic ways. Like just 5 or 6 years ago, we started a responsive interventions for change docket. That wasn't what it was called at the time, but that's trying to catch some of the lower level people who are cycling through to get them to the resources they need. And so we've partnered with services in the community through CSCD and pretrial, because the judiciary can't, people forget, judges, Ed can't just go out and get some services to come act for his court. Richard Woods, our new district court administrator, he can't just go out and get a contract for services to be provided for people in our courts. The judiciary cannot enter into those kinds of relationships, but they can get those kinds of services to the people that are before our courts through the probation department and through pretrial services. And we have very active directors of those who are managing those resources and trying to get those more resources for us, because we do need more community support in those areas. Also, our specialty courts, Mary Covington is our operations manager for specialty courts. Mary Covington is brilliant on the felony side. Seeking resources, seeking agencies who can provide services for the RIC docket, for Veterans Court, for the mental health docket, for the competency restoration docket. We used to have this state jail impact docket, but we've now changed to the emergency response docket that's trying to handle some of our backlog cases from the pandemic and from Harvey. And I think that as our judiciary is understanding the community needs and best practices in how we process cases and how we handle our citizens who are coming through our system, there is a sea change of addressing therapeutic needs. And I think we're going to see more of that. That's not to say that everyone that comes through this system needs those services or those services can help. The judiciary and the criminal justice system still serves an important function for administering justice, whether that is a jury trial for the person, the accused of the crime, and penal, I guess it's rehabilitation, might still be appropriate in some cases. I'm not at all saying we're moving to all therapeutic courts, but there are more therapeutic ways of handling things. And I think we even, with the domestic violence court, that's one way of addressing, and I'll let you talk about that court.
Well, and what you'll also see, so one thing Lisa and I in-house attempt, we don't usually make it on a weekly basis, but we try to read the cases coming out of our relevant courts of appeals as close as we can on a weekly basis to get those to our judges and say, hey, here's one you really need to look at, right? Hey, there's been a change in how the courts of appeals are looking at this particular statute that's going to affect whatever the issue is. Domestic violence, I need you to take a look at kind of how they're interpreting this. There was a huge sea change initially when there was a change in the benches in 2019 as to how they looked at some of the standards for CPS cases. So it was like, okay, trial judges, like they're indicating that there's not enough of a record to show that a parent high on meth is a danger to their kid. You know what I mean? Like, so you need to make sure if that's going to be an issue for you, you build a better record, right? So we definitely try to bring them up to speed on those things. There's also been an effort, I'd say over the last 7 years, for when district courts know there's another district court involved, right? So I have a dual status youth, right? I've got a kid who has a juvenile case and a CPS case. Or I have a mom who has a CPS case and she has a pending criminal case, or she's a victim of a pending criminal case. There's an attempt to make those courts talk so that we don't make those people do overlapping services that make them lose jobs, or make them lose just make things so difficult for them that they want to give up and kind of not continue to do those things. So there has definitely been a cooperation among that I've seen among the courts to say, yeah, I've got that person. Some judges will transfer it to one judge. So you've got one judge in charge of somebody's docket, right? I'm going to handle your mental health issues, and I'm going to handle your kid issues. I'm going to handle it all. And sometimes they just coordinate to make sure somebody doesn't have to use too many people. Does that help answer? Does kind of the three of us help answer that question?
Yes, and also there's a couple of questions in the chat box. One of them is about the assignment of courts. If there is some problems with the case, is there any way that the victim or the defendant can ask for a transfer out of that court? And if so, how do they do that?
Well, there are legal issues first and very procedural issues, especially in felony courts. I'll let Eileen address family courts in a minute, but for our citizens who are facing a deprivation of liberty that involves their body being deprived of liberty, there are many safeguards that we have to ensure in procedural steps and standing. And so who has standing to challenge what, and who has standing to bring something before a court? Traditionally, a victim would not, but the state would on behalf of the victim. So, but then there's also safeguards about fairness and distribution of cases and the randomness of it, and to prevent forum shopping. Forum shopping is a legal term that says you can't go pick the judge that you want to try to get some outcome that you want. That's why our direct filing order is random. It's random on purpose. It's not just random because the judges need it to be random. It's random to ensure that nobody's ever going to, certain cases where a judge might have a particular view aren't always going to end up in his case. Now, there are safeguards about judicial disqualification. If a judge, and this is true for all courts, misdemeanor, civil, felony, family, juvenile. If a judge has a certain involvements with the case or certain biases that can be proved, that judge can be disqualified and the case would be transferred. There's also recusal. And then we have lots of motions for recusals daily, it seems now, where parties are challenging the judge might need to be removed from the case for some particular reason that they're alleging. Usually it's bias, but there are rules and specific elements to have to prove recusal. And again, that's because you shouldn't be able to just go, I'm always going to want to go to Judge Amy Smith because she's the best judge ever, and Judge Lisa Teachey is horrible and I never want my case in front of her.
Truer words have never been spoken.
But I would say, I would start with the assumption. So in criminal court, a victim, right, is going to not have that independent voice to be able to do that. And I would ask the state, right, just because judges, you can misinterpret a judge's feeling about something, right, where all they're trying to do is make sure that they're abiding by the Constitution and they're right and they're following the law, that you think that somehow they're biased against you and don't like you. And that isn't at all, in all likelihood, what it means. It means that they're trying to make sure that they're going to get an incredibly fair process and proceeding done so that whatever happens, either through a bench trial or jury trial or plea, is upheld on appeal so that what happens actually can kind of stick and be final.
There's another, thank you for that. There's another question about, there's actually two more questions. Is there a way that a person who has cases in different types of courts, for example, criminal and family, request that those cases be looked at together?
In Harris County, no. In Harris County, for our district courts, the answer to that is most likely no, because our courts have very specific jurisdiction that are granted through statute. And so when you go look up the 179th district court, you'll see it's a court of general jurisdiction. And you'll be like, okay, well, they can hear everything. But no, then there's other government codes that statutes that say when you're in a jurisdiction that has one or more courts, they have to come together and make rules of administration of how they're going to handle courts. And in Harris County, we have decided that there are 4 divisions, and we have decided which courts we're going to assign to those divisions, and they are going to specialize in those. Can a district judge sitting in I'll pick the 209, because I know that that's a court of general jurisdiction that's supposed to specialize in criminal according to the state legislature. That's enacted by law. And then so we've put them in our criminal division. Is that judge allowed to hear any kind of case they want to? Absolutely, they can under the exchange of benches statute. So it's all very technical. It would seem like the answer is yes, but there's administrative rules, and And we have to have these in place because otherwise we would just have things all over the place. And you want your judges to be specialized in their areas. I think I would kind of say the same thing because his misdemeanor courts are different from his county civil courts at law. And before I throw that to him for that, I just want to circle back to something we were saying earlier before the questions open. And Ed taught me this many, many years ago. Before the pandemic, before Harvey, people you routinely forget that Harris County has sort of a Mayberry attitude, but what we do with criminal justice in Harris County is such a massive undertaking that if people understood what we do on a daily basis, and most of the time we're getting it right, that to just keep this ship moving forward is unbelievable if you stop to think about the people that are coming through JPC, the people that are coming through our courts and how we're dealing with our cases.
Yeah, and I'll just be there before you. I would agree with Lisa. You probably wouldn't want a family hearing a criminal case or a criminal court hearing a family case because they're so specialized and they're not going to know the nuances of kind of what they're supposed to look for. Mm-hmm. If it's juvenile to family, I'm probably not going to have heartburn about that. And we have combined juvenile family cases before. Absolutely.
Maybe
I just learned something
really quick because maybe I misunderstood. I thought that you said that judges across different practices, basically, if there's a person who has the different courts will kind of come together and say, oh, I have this person. Oh, I have this person also. So we're not going to duplicate what they have to do, right?
Yeah, like they
Absolutely.
communicate, but they don't mix the
They don't adjudicate. They communicate but don't adjudicate.
Right. I guess I was asking because I was with the probation department for years, and we had the issue where the criminal district court judge would want them to do parenting classes or this, that, and the other, and then the family case with CPS and all the everything that goes into that would also want them to do the same services, but then there was no communication between the two, like, oh, this was done over here and this was done over there. So that's why I was just asking.
We're getting better.
We're getting better.
We're getting better at that.
We're not great, but we're getting better.
We're getting better at that. And I think Ed wanted, we're getting better. Ed, did you want to jump in on the?
No, I think you explained it well. And the same would be true for us because we'll have defendants very often that have a misdemeanor case and a felony case. And so the courts may not communicate, but certainly the attorneys are communicating across both. And occasionally we'll have defendants that have a family law matter. Again, that's the attorneys communicating more so than the courts. But that is a concept in other jurisdictions that has been tried. I think in Harris County, the challenges are, again, specialized practices, so to speak, as you said, and also just the sheer volume.
Yeah. And Jessica, in theory, the PDO's office has opened up a holistic division to be able to help individuals when they had a criminal case and they also have a kind of an attached family or related case. So that's another kind of touch point that they're trying to make that a little better for kind of the parties who are
right. And in the county courts, the manager assigned counsel department has a similar service available. So,
and volume seems to be the issue. Like we know Harris County is the third largest county in the United States, right? So again, we have this issue of volume regardless of backlog. It's right. We already have a tremendous amount of cases that are filtering through. And Lisa, thank you for saying that. And Ed, thank you for the education, because I mean, I think that's critical for us to have understanding around. I know we're getting close on time. There's one more question in the chat. I do see a hand up, and I have a closing question for you all. So I'm going to try to facilitate this pretty quickly. The other question in the chat was, I think it was Eileen that you were talking about this. Can you talk more about the protective order having more accountability than bond conditions right now?
Yeah, and I'm not sure necessarily has more. I mean, I probably used a bad word, and I apologize for that, but it's just with SB 6, if I get this wrong, Lisa can flat me down. the changes that they want to implement in terms of having bonding conditions be uploaded so that basically into DPS, so everybody knows that there's that specific bonding condition, is a difficult, arduous process, right? And so I think about the individual who they have that and they don't have a protective order, which I know is uploaded into DPS, which I know will be found across the state, right? So that if I have somebody stalking somebody and they follow them to Austin, I know they're going to find that protective order. I don't know they're going to find the bonding condition.
Excellent
Right.
point. Yeah.
That's the like, for me, that I'm like, why would I not get that for somebody?
Right, and if I can help her out there just a little bit,
If I screwed it up.
no, you did not, no, but what's important to realize for those who are familiar with HB 766, which is the new Code of Criminal Procedure, Article 1750, which requires all courts to report bond conditions for certain violent offenses and all family violent offenses. DPS just took that MOAP reporting form and put put HB 766 on top of it. So a lot of ours right now are going over as other, even if they're family violence. And so we do have to report them, but they're going to be going over as other instead of being able to tell the officer who's going to look this up that it's a family violence issue. Ed has an employee named Sylvia Cherry who's brilliant. And so she and I have been working with DPS going, this doesn't work. This doesn't work if this is what you're trying to get the information out there. So when y'all start hearing about HB 766, Article 1750, and that we're supposed to be reporting these and it's just not working, no, it's not us. KNOW, it is not us. It is.
Well, and what I'd like to do is maybe that's a specific issue we can have another follow-up conversation with you all about.
I thought we were going to have time.
Well, we're gonna make time. I think this is really important, and we're just touching the iceberg of that. So be on the lookout, Lisa and Eileen. I'm sure we'll be coming back to you.
Yeah,
So
we've also been having conversations with the sheriff's office about that because the sheriff's office is responsible for doing it. So I've been having conversations with the sheriff's office about that because people are asking, the domestic violence service providers are definitely asking that. And I've been in conversations with the sheriff's office. So I would love to talk with you about that because y'all are.
And Amy, call me next week because we have a regular meeting on HB 766 that you probably ought to be involved in.
Okay, great. Thank you, Lisa. Okay, sorry. Tracy,
I saw your hand up.
Yeah, I'm sorry. I had a quick question about the magistrate judges. I know that you had you mentioned that they're appointed for a year, and I don't know if I missed this in translation, but once the year is up, and I know that they will wait out until they're reappointed. Do they still act, or what happens? And then I think another question I had is it a pool of people that you guys begin to move around when it comes to the magistrate judges? I don't know if that makes sense, but
I'll try to address that best I can. The 1 year is by statute a 1-year appointment, and again, if their year ends and they haven't been reappointed yet, they continue in their position and have full authority until either they are reappointed or a replacement is appointed. So they maintain doing what they're doing beyond the year if there's not an appointment immediately. With regard to the pool, we currently have 12 magistrate positions. We have criminal law hearing officers is what we call them by statute. We have 9 employed. We're filling 3 more positions, hopefully very soon. We really need to get that to a higher number so that we have more hearing officers available on every shift at the JPC. And so it's not a pool. When we have a vacancy, we post that job, we send it to everyone we can think of and then some. People apply, we interview just like you would for any other position, and then that committee appoints.
Thank you. In closing, I just kind of we have a magic wand question we've been asking of all of our guests. And first, let me thank the three of you for spending your Thursday evening here with us. You didn't have to, and we are so appreciative that you have done that. I also thank the audience, all of those of you that have checked in to be with us this evening. Thank you for taking the time. It's so important and it means so much. So in closing, and just in a couple of sentences, if you had a magic wand and you could wave this wand and it could do anything that you wanted it to do to make things better for our community and citizens in terms of the court system's response to domestic violence. So we're going to drop the lens very specifically on domestic violence cases coming through our civil and criminal court systems. You all have the wand, you can wave it. What would you do?
Specifically, I would look at distilling that data down to the point where we all recognize that in domestic violence cases, there's some element of escalation of behavior, right?
Yep.
How can we identify that better and educate judges on how to use that data to make
Yep.
better decisions with regard, and we're getting to that place where we can start to do that. But there's not been enough science on it. So some of this is research, some of this is just, this feels best and it's trial and error, but we've got to start doing that, because locking up everyone is not the answer, and letting everyone run free is not the answer. And when we make decisions for either of those, we need to do it based on the data and the science that says this person, based on these factors, is of higher risk, right? To reoffend, to harm someone. And that's really what we need to be looking at.
Ed, it's beautiful to hear you say that, because I think we've got some things to help you out on that.
Perfect.
So we will definitely be following up with you. Lisa or Eileen?
I actually had written down for the felony courts, one of our biggest obstacles, and I don't know the answer to this. My magic wand would be that we would find an answer, because it's not really a problem that the judiciary can solve, but it's a problem that the community could solve.
Mm-hmm.
And I know that all of y'all work every day to solve this, but and in fact, I heard a judge saying this just this afternoon. I've got the victim there. I'm trying to get the information, and she doesn't want to give it, or he doesn't want to give it. And there's not much more I can do when we're trying to do a condition of probation or a condition of bond. And there's not an answer for the judiciary on that, but there has to be an answer for Harris County and for Texas, and for the services that we can provide and the education that we can get out there to people who are in these relationships, because we're in an era now where these kinds of things touch all of us. Family violence, it touches my life now, it touches your life now, it touches everybody's life now.
Absolutely.
It's not just across the tracks and happening over there. It's the same with drug use and the other issues, the mental health issues that we're seeing. And so I don't know what the judiciary can do, but if I had a magic wand, I'd wave it over Harris County, and that would be one of the things I would wish for.
Thank you, Lisa. Eileen?
You're all right. So, okay, I'm going to answer two ways.
Okay.
Practically, if I had a magic wand, so if I was just analytical, I would have the executive branch fund more specialty prosecutors and specialty defense attorneys who understand domestic violence, right? And would understand where those risk factors are, so that we can actually get people and families to safety, right? In a much more efficient way, right? And that also goes with educating our judges along the way. But if you told me practically what can you do, give me the money, give us the prosecutors, give us the defense attorneys, know what they're going to do and make the system function. From a completely unpractical standpoint, if I had a magic wand, I would make us a kinder society. I'd make us understand that everything goes in together, that when I take poverty and I add in lack of education and I add in lack of people's desire to hire somebody who is from that place, and I push people down so that their kids are selling drugs when they're 13 years old, it is money. But you know what? Spend it there. and have people have some decency in the community to help people across the board get themselves to a better place in life. Because we all know domestic violence that doesn't even touch a kid touches their brain. We know that children's brains shrink when they see their other parent injured.
Yep.
That affects every aspect about them for their entire life, right? So I would somehow magically make our community have that kindness and understanding and give a little more to people.
Ooh, I wish this magic wand existed. The three of you would have made massive, incredible change. Ed, is your hand up to add more?
Yeah, just very quickly, adding to what Eileen said, keep in mind that many of these issues, domestic violence, mental health issues, substance abuse, all of that are social issues. We all recognize that.
Yeah.
And society in general hasn't applied the resources necessary to address it. And
Agreed.
so it's come to the courts, through
Agreed.
criminal justice and family matters, to be addressed. We need the resources necessary to do that.
Agreed.
And the good part about it from the perspective of courts is the courts have a hammer that other institutions do not, but it's also one of the most expensive and onerous ways to address it. So if we could do it outside of criminal justice, we could do more and better work, right?
Agreed.
But today we can't.
Agreed. It should be the last resort. It should be the last place we get to, right?
Correct.
Absolutely.
The three of you you just changed the world for us with those magic wand wishes. And thank you for that. Your passion, your wisdom, your dedication, your years of experience truly matter in our county and to our citizens. So thank you for that. I don't think I can underscore how important it is to have folks like you doing what you're doing to keep that ship on its track for the volume, the backlog, all the things that we're up against. So truly I thank the three of you for doing what you do and for being with us here tonight.
Thank you for
the
having
invite.
us.
I
Thank
know,
you.
it's lovely.
Thank you indeed.
Well, we've got some action items to come out of this. So you'll be hearing from us at the coordinating council. To our audience, thank you for spending your Thursday evening with us. I know many of you out there are engaged in incredibly difficult work, working with people who have experienced trauma, are working to survive that trauma. Judge Finch, thank you for giving us your evening this evening. Judge Baldwin, I can't underscore and express enough how we've all experienced so much in the past 2 years, and there's more and more coming, but my heart and my mind are refreshed and renewed every time I'm in meaningful gatherings with people who care. So thank you.